EEO stands for Equal Employment Opportunity and refers to the practice of following all federal and state laws prohibiting discrimination in the workplace. It is illegal to discriminate on the basis of race, color, age, sex, pregnancy, disability, religion, national origin, military status, or genetic information in employment practices. Federal law has protected the members of these groups with several landmark laws and their amendments. The Civil Rights Act of 1964, the Americans with Disabilities Act of 1990, the Pregnancy Discrimination Act, the Age Discrimination in Employment Act of 1967, the Genetic Information Non-Discrimination Act of 2008, the Employment Non-Discrimination Act, the Uniformed Services Employment and Re-employment Rights Act. All employment practices, including recruitment, hiring, promotions, demotions, job assignments, compensation, training, discipline, and termination, are covered under these acts. These laws have defined personal characteristics that form what are called protected groups. These groups include race and color. It is illegal to treat someone unfavorably because of race or racial characteristics, such as skin color, hair texture, or facial features. Age. Age discrimination can only occur against persons 40 years of age or older. However, employers are allowed to favor older workers over younger ones. Federal laws do not protect persons under the age of 40, although several states do have laws protecting younger workers. Sex. Sex discrimination is illegal and occurs when persons are treated unfairly due to their gender. The Equal Pay Act mandates that men and women receive equal pay for equal work. When jobs are substantially equal based on job content, then the men and women in those jobs must receive equal compensation. Compensation includes salary, bonuses, vacation time, insurance, and any other benefit received on the job. Although federal laws against sex discrimination don't specifically mention gay, lesbian, bisexual, and transgendered persons, recent court rulings have shown that these groups are protected from discrimination on the basis of sex. Guidance from the EEOC states that persons in these categories may bring discrimination claims if they experience adverse employment actions for not conforming to sex stereotypes or for harassment based on sexual preferences. In addition, gay, lesbian, bisexual, and transgendered workers are specifically protected from discrimination in many states and if they work for the federal government. Pregnancy. Unfavorable treatment of women because of pregnancy, childbirth, or any medical condition incurred as a result of pregnancy is illegal. Under federal law, employers are required to treat pregnant employees in the same manner as other employees with temporary disabilities. For example, if the organization provides paid disability leave for temporarily disabled employees, then this leave must be extended to pregnant employees as well. Under the ADA, pregnant workers must be given reasonable accommodation if needed, which enables them to continue to work. In most cases, workers who have been with their current employer for at least 12 months are eligible for up to 12 weeks of unpaid maternity leave under the FMLA. Employees must receive their previous position or another position with the same level of responsibility, pay, and benefits when returning from maternity leave. In addition, employers must provide light duty or a temporary job reassignment if needed to accommodate an employee during pregnancy. Disability. Disability discrimination occurs when persons are treated poorly or unfairly because they have a disability or because they have a history of disabilities. The law also protects persons who are perceived to have a disability, even when they do not actually have one. The Americans with Disabilities Act states that persons with disabilities must be given reasonable accommodation in the workplace, unless those accommodations would cause the employer an undue hardship. This means employers are required to modify things like workspaces or work schedules to allow disabled workers to do their jobs. Religion. Treating a person unfairly based on his or her religion is illegal. This type of discrimination includes traditional religions such as Christianity, Judaism, and Islam, as well as less common but sincerely held religious views and strong moral beliefs. Employers may not segregate employees based on religious practices, such as placing persons of a particular religion in non-customer positions because of dress or grooming habits. In addition, employers must adjust work schedules for religious practices if they are only a minimal burden on operations. National origin. Unfair treatment of persons from a particular country or section of the world is strictly prohibited. This includes discrimination against persons of a particular ethnicity or with a particular accent. It is illegal to require English to be the only language spoken at work, unless speaking English is critical for the safety and efficiency of operations in the workplace. Employers may not base hiring decisions on immigration or citizenship status, except when citizenship is required by law. So long as a person is eligible to work in the United States, all treatment must be fair and equal. Genetic information. The Genetic Information Non-Discrimination Act of 2008 prohibits the use of genetic information in employment decisions. Genetic information includes the genetic tests of an individual and his or her family members, along with family medical history. Military. Employers are prohibited from discriminating against persons on the basis of their military status or obligations in the military. In addition, re-employment rights for active duty and reserve military members, as well as veterans, are protected by several different federal laws. It's also illegal to discriminate against a person because of his or her spouse's membership in a protected group, discriminate based on a person's membership in a group or organization which is associated with the protected group, regardless of whether that person is a member of that protected group. Discriminate against a person because they are perceived to be a member of a protected group, even if they aren't actually a member. Retaliate against persons who have asserted their rights under federal employment laws. It is important to note that employment practices that unintentionally discriminate are also illegal. For instance, having a minimum height and weight requirement for a job might unintentionally discriminate against certain minorities and women. However, if the employer can prove that the policy is a business necessity, then it is not considered discriminatory. In addition to federal laws, many state and local EEO laws have been enacted, which cover many other groups of employees. It's vitally important that every organization familiarizes themselves with both federal and local guidelines. Federal law prohibits both quid pro quo and hostile environment harassment. Quid pro quo harassment occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. Hostile environment harassment occurs when harassment based on a person's status in a protected group is continuous and unwanted and unreasonably interferes with an individual's work performance or creates an intimidating, offensive, or hostile work environment. Following EEO law is really pretty simple. Every employment decision should be made on job-specific factors only and never on the basis of race, color, age, sex, pregnancy, disability, religion, national origin, military status, or genetic information. And preventing harassment against members of protected groups should be a top priority. Organizations who follow this guidance will have taken a huge step toward complying with federal equal opportunity laws. However, every employment decision should be carefully evaluated to make sure it meets all local, state, or federal legal standards. Laws enacted over the past 50 years have not only given millions of employees fair and equal opportunity, but they have made our workplaces safer and more productive as well. Carefully following EEO law is not only required, but it will make your organization stronger and therefore more successful.